Okay, good morning and welcome to a very special webinar from the Mashreq Construction Club. This is our first edition of the Connect series for the Mashreq Construction Club. So we're taking our regular construction forums online into working from home mode. For those of you who are established members of the Mashreq Construction Club, welcome back. Thank you for joining us today. For those of you who are joining us for the first time, I'd like to tell you a little bit about what we are and why we exist. So the Mashreq Construction Club was established in 2017, and its purpose was to really drive better construction and a better construction industry in the UAE. And I think with the events of the past 3 months, the COVID-19 pandemic and the social distancing lockdown that have disrupted so much of our lives, the aims of this forum really are more critical than ever. So we've had 5 challenging years in the construction industry in the GCC. We've had a reduction in the number of new projects, late payments, disputes. Over the past 2 months, we're now starting to see severe disruption to supply chains and some activities on some projects becoming impossible to deliver. So this raises all sorts of contractual challenges. And the purpose of today's webinar is to really look at what are the options for construction companies and their clients and everyone else involved when you cannot deliver your contractual obligations. If you feel that there's an impossible situation and a force from above has stopped your ability to do work. So that is the point of today. So we've called this webinar Force Majeure and Other Options, and we want to look at what those options are and what the potential consequences of those options are. Today's session is going to be led by 2 extremely expert lawyers in construction in the Middle East. So Michael Gross and Matthew Haywood, I will tell you a little bit more about them later, but they're both construction partners with Clyde & Co., one of the biggest law firms in the world. And we're going to have a presentation from Michael and from Matt, and then we'll go into a discussion and some questions and answers. So please take the opportunity to submit your questions. This is a very, very important issue for many of you, I know. And if you have contributions or experiences, send us those as well. There's at the bottom of the screen, you can see a Q&A icon. Put your questions in through there. The questions will come to me and I'll moderate them out. And one final point before we get into the program. This is our first webinar. A lot of the content or the issues that face companies at the moment is coming out of the blue. It's new. We want to produce, or we're going to produce this series on a regular basis. Every 2 weeks we will have one of these seminars. We've got a clear idea of what we've done, some surveys. We think we know what people want to discuss and ask about, where your pain points are and your fears. But please submit your suggestions or ideas if there are any themes you would like us to cover in the Connect series. So that is enough from me. Actually, I should introduce myself. I apologize. I'm Richard Thompson. I'll be your moderator today. I'm the editor of MEED, and so I'll be moderating today. But the host for today is our next speaker. It's Mohammed Al-Qadr. If we can go to the next slide, I'm going to hand over to Mohammed from Mashreq Bank, who is going to say a few words of welcome. Over to you, Mohammed.
Good morning, everyone. I hope that you are all safe and healthy. On behalf of Mashreq, I would like to welcome you to our first Mashreq Construction Club Connect series. Being a regional bank established more than 50 years ago and headquartered in Dubai, Mashreq has always been working closely with the construction industry and will continue to do so in the future. We have embarked on a knowledge partnership with MEED to establish a platform which would allow for this industry's voice to be heard and to address its issues and concerns collectively. Since the beginning of March, we are all hindered by the unprecedented sweeping pandemic, which disrupted a lot of our activity, under this initiative. Hence, we are starting the Mashreq Construction Club in its virtual form and plan to bring it to you regularly. Again, good morning, welcome, stay safe, stay connected. Thank you.
Thank you, Mohammed. Just to give you some background, for those of you who have not been involved with the Construction Club previously, so we launched in 2017. This was when the construction industry in the UAE and across the wider GCC was facing the problems that we've seen over the past 5 years with a slowdown in new project spending, delays in payments, liquidity problems, disputes, and all sorts of the issues that result from bad practices and a slowdown in the market. And the forum was established to really bring together leading figures from across the UAE construction industry and extending into the wider GCC and Middle East region to really look at what are the opportunities to do things differently, to try and drive efficiency, reduce waste, reduce disputes, and save time and money and effort. And you can see on the screen in front of you, we've had a number of sort of outputs that we've delivered over the past 3 years. And so we have a website hub for the content, which is all construction, innovation and contract related, a series of research reports, which I'll just show you in the next slide, the clubs, which meet generally every quarter, but we're now taking online with these Connect series webinars. And we've done other things as well, findings reports and other webinars. If we can move to the next slide. So we're now, this is the construction reports that we have published over the past 3 years. We've done 9 have been published so far. There is another one coming out next week, which is looking at waste in construction and ways to reduce waste. And so if you can find all of these on the link that I just showed on the previous slide, which is the MEED Mashreq Industry Insight Hub, and we'll circulate these slides afterwards. And there's one final thing I want to tell you about before we move into the Clyde & Co presentation. This week, the UAE Construction Think Tank, which is part of the Construction Club initiative, published its second white paper. Now, this white paper is quite important. It has, we had a group of very senior construction people from government, from academia, from industry, and from law firms come together to look at how can we create better contracts for construction, contracts that will reduce waste and reduce disputes and get rid of some of the inefficiencies. The paper, which is on, you can see the link in the blue text at the bottom of the slide. You can click on it, and there should be a pop-up on your screen now. In the chat icon at the bottom of your screen, there's a direct Dropbox link to this report. It contains about 26 recommendations for how to improve construction contracts in the UAE. I think a lot of the lessons and recommendations are pertinent to the wider GCC region as well. So I do encourage you to have a look at that report, send any feedback to us. So if you click on that chat icon at the bottom, there's a Dropbox link and you can download the report. Okay, if we can move to the next slide, I'm going to let's get on with the program for today. So we have 3 fantastic panelists. So on the left-hand side of your screen, you can see Michael Gross, and in the middle, Matthew Haywood. Michael and Matthew are both partners with Clyde & Co, the international law firm. Just to briefly read out the bio notes, sort of headline bio notes. So Michael is a construction and projects partner at Clyde & Co. Huge experience in the Middle East. He's been in the Middle East market since 1998, becoming a partner at Clyde & Co in 2004. He advises on construction contracts, particularly specializing in FIDIC, and a lot of experience in arbitration, which perhaps Michael can tell us a bit about that towards the end of the seminar. It's an area of focus for him. For Matt, he is the construction disputes partner at Clyde & Co. He specializes in dispute resolution and risk management. Again, huge experience in the Middle East and in the in the UK and internationally. And he leads teams acting on arbitration as well. So vast experience from both Michael and Matthew that I think will be valuable today. And then the figure on the right-hand side, that is Colin Foreman. He is MEED's deputy editor and is our construction lead at MEED. Colin has been covering the Middle East and the Gulf construction industry for 15 years or more, vast knowledge and a huge network of contacts in the construction industry. So together, hopefully, we can cover the legal basis and the sort of what's going on in the market as well. So thank you to the three of you for being available today. Okay, so I'm going to hand over now to Michael. We have about 10 slides or so from Clyde & Co. It should take about 15 minutes. Please send in your questions and comments as we go. You can see at the bottom of your screen there is a Q&A icon. If you want to submit questions, and we've had a few already, what I suggest we do is we listen to the presentation, submit your questions, and then once we get to the end, I will moderate those questions and we'll field them to Michael and Matt and Colin. And if there are any for Mohammed from Mashreq as well, that might be pertinent also. So use the Q&A box at the bottom of the screen. Over to you, Michael. Thank you.
Good morning, everyone. I hope you're well and staying safe. Thank you also, Richard, for that introduction, and to Mashreq Bank for continuing the support of this construction club. I think it's a really valuable resource and a great forum for the construction industry. And thank you for this opportunity to speak and to address you all. So what we're going to do, actually, could you go to the next slide, please? What we're going to do, Matt and I, is we're going to break this up into three parts. I'm going to start off with just a general scene-setting introduction based on this slide here, and then Matt is going to take us through the contractual aspects of this topic, and focusing particularly on FIDIC, of course. And then I will come back and cover off the last two topics, which are going to be the applicable law and methods of dispute resolution. I'm aware that a lot of people who are listening in are going to be at the coalface of this particular issue, facing disruption on construction sites, issues with transportation of labour, disinfecting labour camps, and basically trying to comply with all the rules and regulations that are coming out on a regular basis from various different government departments and ministries. What I'm not going to do is try to take you through each and every item or law or regulation that's been passed over the last few weeks, because that would be very difficult, and I suspect there are others with better knowledge of that. So we are going to focus instead on the sort of general application of contracts and laws to this particular topic. The general theme over the last few weeks since the lockdown was implemented has been that we tend to see quite broad-ranging, draconian laws and directives issued, and then subsequently those are refined or clarified and exemptions are given. And so keeping up with that certainly has been a challenge. And we do have a list, a chronological list of all the laws that have been passed, if anyone's interested, and I can certainly provide that separately if you want to get in touch with me afterwards. There's also been a bit of a challenge in distinguishing between some of the real news and either fake news or news that is quite difficult to source. And so care is required, I think, to make sure that when we're reporting and looking at the most recent developments, that the source is reliable. But regardless of all of that, a broad theme, I think, of this presentation will be that construction to some extent has been isolated from the immediate consequences of the lockdown, because although the laws and circulars that have been issued have started out being wide-ranging, exemptions have been granted then subsequently to construction to make it clear that they don't apply universally to construction sites. And that I'm talking mainly about being in the UAE, but I believe it's the same elsewhere. But notwithstanding that, construction is certainly not exempt from the economic consequences of the current pandemic. And so, as Richard has said, there are issues with the supply chain, there are issues with getting labour in sufficient quantities to site, and other consequences of the current situation. Similarly, in macroeconomic terms, I think we can expect some sort of parallels with the global financial crisis. We already know that Expo 2020 has been or will be delayed by a year. We know that some big developers are looking at slowing down their projects. And we know, as I think probably most of you will have seen, the Department of Finance and the government of Dubai has issued guidance to government departments asking them to look for savings on construction projects and to defer expenditure wherever possible and undertake value engineering exercises. So there will be a broader macroeconomic effect of force majeure of the pandemic. And against that backdrop, what I want to do is sort of subdivide this topic into three main categories, starting with the contract, which is always a good place to start, assuming you have one. Then move on to the applicable law, and that will be focusing very much on the applicable law in the UAE, but the GCC countries do also all have similar legal systems with a civil code that is broadly the same as that in the UAE, with the exception of Saudi Arabia, which has no civil code. And then finally talk about how a lot of those contracts and applicable laws are likely to be applied, depending on the type of dispute resolution mechanism that you have in place under your contract. So on that basis, and without further ado, I'm going to ask Matt to take over and speak about the contract. Next slide.
Thank you, Michael. Good morning, everyone. And to echo Mohammed and Michael's words, I hope this finds everyone safe and well in these difficult times. As set out by Michael, I'm going to run through some of the key contractual provisions that should be considered during and after this COVID-19 period. That in itself is a very broad topic, and we don't have too much time today. So I'm going to limit my discussion to the 1999 FIDIC Red contract. I do acknowledge there are lots of other standard form of contracts out there, including the 87 FIDIC, which I may refer to as we go through the presentation. This first slide essentially is a roadmap, an overview of what I'm going to discuss over the next 10 minutes. If you have any questions, as Richard said, please do fire them in, or indeed, please follow up afterwards if there's anything you want to take offline and discuss with us. Next slide, please. So I've been, as you might expect, discussing key contractual provisions with clients in quite a lot of detail over the past few weeks. And the first question I'm usually asked, and indeed the clause that has generated, I think, the most column space and articles is about force majeure. And I think it's quite right to address that clause. But before we get there, what I want to do and what I want people to stand back and take a bit of consideration over is the other clauses within the contract that may be relevant to your projects. And the first of these I want to talk about is clause 8.4, which is the extension of time provision, which may provide relief. And the unamended 8.4 in the FIDIC Red contract provides for an extension of time entitlement if the delay is caused by unforeseeable shortages in the availability of personnel or goods caused by an epidemic or governmental actions. Now, on the face of it, this clause would seem to give scope for relief, but I note that the clause refers to all governments rather than a specific government. So this clause is actually quite important if unamended in relation to supply chain considerations. But my chief concern is, and having experience in this region, is that this clause is often heavily amended and subclause D is taken out. But if it remains, a further point which I think we need to consider, because there are going to be a lot of grey areas in contracts and in discussions going forward, is, well, what is the definition of epidemic? Many are taking for granted that COVID-19 is an epidemic, but I've been in enough disputes to know that one has to anticipate every single point that can be taken in defence of a claim is taken. So I've had to think about this, and the World Health Organization on the 11th of March declared the COVID-19 a pandemic. The Health Organization's definition of pandemic includes epidemic. So on the face of it, I think we should be fine there, but I'm flagging this as a potential area where expert evidence may have to be used in the future. Remember, with clause 8.4, and in fact with all clauses in your contract, notification. Keep in mind clause 20.1 and keep notifying those claims on time and within the time periods. The second clause on this slide is 8.5, and it's one that I think has been slightly overlooked over the past few weeks, and in its unamended form, it may well be relevant. This clause essentially relates to delay or disruption caused by a procedure implemented by a public authority. Well, we're seeing a lot of those at the moment, but you'll note that this clause also introduces a foreseeability test. Foreseeability often being defined in standard FIDIC contracts. So I foresee here, therefore, a risk that another party, an employer, may be able to argue that in light of the recent history of novel viruses, SARS, swine flu, MERS, the emergence of another virus was in fact foreseeable and could have been predicted. However, you could extrapolate that argument out and say, look, anything you could imagine could potentially be foreseeable. And I think outbreaks of new viruses are not everyday experiences. And I would suggest that the specific effects of COVID-19 on the entire world were far from being reasonably foreseeable by an experienced contractor or by anyone else. So there's a strong argument to be made out there that this requirement is satisfied. However, keeping a close eye on the latest directives and circulars from the government is key. And as Michael said, we'll be delighted to provide our weekly updates to you should you wish. Next slide, please. So you'll know we're not at force majeure yet. I want to take you through another couple of clauses before we get there. Clause 13.7 is an important clause, and if unamended, it allows for additional time and money in relation to changes in legislation. As a result, this is another clause that is often amended with the risk being transferred to the contractor in this region. And unamended, it has limited scope in that it must relate to a change in a law. But checking the definition of laws within the standard FIDIC contracts, it normally relates to regulations and bylaws. And so as we see new legislation and new laws coming through, please keep in mind clause 13.7, because if a contractor can identify changes in law or regulations arising from a result of COVID-19, which then have an impact on the works, it may have a ground to claim for additional time and cost. I've also put on this slide clause 13.8. I have almost universally seen a red line drawn through this clause in contracts in the region. But if you still have clause 13.8, read it. It relates to price escalation for materials and labour, and may also benefit you when you're looking at claims in this time. Next clause, please. Right, so we're finally here at force majeure. There's been a lot spoken about this and written about this in coming weeks. I just want to try and break it down into its most simple elements. So essentially, clause 19 sets out a test and it gives an example list of events and circumstances which may constitute force majeure. The first thing to notice in the standard form is disease and/or epidemics are not specifically listed. Now, this is a standard list of events and circumstances, but the key point here is it's not a limited list. It is non-exclusive. So on the basis of the more general test in clause 19.1, an argument can be constructed that the COVID-19 outbreak would, in principle, be covered by the general definition. What are the elements? It has to be an exceptional circumstance. I think we can agree that's the case. Caused by neither party, once again, yes, which the contractor could not reasonably have provided against, avoided, or overcome. And I think that's fair enough to say as well. But what I did say was, this is in principle. My concern here is the COVID-19 event has happened. It is occurring. And yet the UAE, in the UAE at least, the construction sites are, by and large, still functioning, albeit on a disruptive and less efficient basis. And so my challenge is that careful thought must be given as to whether a force majeure event has actually arisen. So let's pause here a little bit and let's explore the wording of the clause a little bit more. How can we be certain a force majeure event has arisen? Well, if you look at the wording in clause 19.2, we will see that the event or circumstance must have prevented the party from performing an obligation. The word prevented is also used in 19.4. It is my view that there's going to be lots of debate over the coming weeks, months and years over what the word prevented means. To assist, synonyms include stopped, blocked, impeded, prohibited, which suggests that an obligation can no longer be undertaken. On that basis, it may be difficult to maintain a force majeure event if it has, say, merely caused disruption. The prevention, in turn, is linked to the definition of obligation. And here we have a broad definition. The clause refers to any of the contractual obligations being prevented. So, for example, one could refer to clause 8.2, the time for completion, or clause 8.3, compliance with the programme being prevented. It is here where we may also see further disputes, because I can see arguments arising as to whether the obligation is still capable of being performed, as opposed to it simply becoming more costly and time-consuming. For example, what if the contractor relied on that clause 8.2, the time for completion, and the employer issues an EOT, the completion date is extended? Has that prevented a contractual obligation? Next slide, please. So having wrangled with and established the definition of force majeure, a party must then consider how the relevant event or circumstance impacted on the works. Remember, at this point, a notification should be put in. Think about that clause 20 again. As you'll see on the slide, the first subheading in clause 19.4 is that a party may then be entitled to EOT. However, entitlement to cost under the unamended FIDIC contract is slightly more difficult and a slightly more limited scope, because entitlement for costs, you must demonstrate that your force majeure falls within the listed examples of force majeure in 19.1 in subparagraphs 1 to 5. Now, this is a limited list. There's no mention of disease, there's no mention of pandemic or epidemic. But in subclause 5, there is a reference to natural catastrophe. And so what we will be exploring with clients is how wide that definition is and whether we can include a pandemic as a natural catastrophe. So once we've got to this point, it's worth looking also at 19.6, which isn't on the slide, but 19.6 provides that if the execution of the works in their entirety or a substantial part is prevented for a continuous period of 84 days, or multiple periods totaling 140 days, either party may serve a notice to terminate the contract. Now, this is important, and the contractor should be aware that if the contract is terminated, it will usually be paid for work done, materials produced, and other costs reasonably incurred, usually excluding profit. One clause which, again, hasn't had as much airtime as the general force majeure clauses is 19.7. This is the impossibility clause, and it's somewhat broader than the more regular force majeure specific clauses and covers all events and circumstances. Whilst the legal impossibility elements may not quite apply yet in the UAE, although do consider issues such as restrictions of workers between Emirates, for example, the physical impossibility elements may well apply, i.e. site access, ability to get enough labour to site to undertake the works. So this is a clause which I would recommend that you look at. But once again, contractors and people relying upon this clause have to realise that the works need to be impossible. That is quite a high bar, and not just difficult or more expensive. So the doctrine of force majeure is unique, and I want to make the point that it's very specific to each contract. In our business and with a collective experience of many decades between us, we see lots of amendments to contracts, and we tend not to see any two force majeure clauses that are the same. So I would encourage everyone to very carefully check the wording of their contracts. To determine whether this pandemic is a triggering force event in any particular context, scrutinise the contract, but also the underlying facts relating to why one party is seeking to trigger that clause, because you can be sure that the other party will be looking at that and scrutinising it. Is there really a casual relationship? Just because COVID-19 exists, that doesn't automatically mean that a party's been delayed. The effect as well as the cause needs to be very carefully thought about. Finally, on force majeure, I've considered some past events which may provide a parallel to this COVID-19 situation, such as major natural disasters, terror attacks, the 2009 swine flu outbreak, to try and draw some context. My conclusion is that during those events, some force majeure clauses worked, some force majeure clauses didn't. And a lot came down to the specific wording of the clause, but also the dispute resolution forum in which the interpretation of that clause was being analysed. And Michael will talk a little bit more about dispute resolution forums later on. Next slide, please. So I'm conscious of time, and I'll have a very, very quick canter through this slide. What I want to get across, though, really is the theme of let's not just focus on clause 19.1, let's not just focus on the EOT clauses, let's have a really good look at all our contracts. So, for example, in the standard FIDIC, look at clause 2.1. This places an obligation on the employer to give the contractor right of access to, possession of, all parts of the site. Now, a failure to comply with this obligation triggers an entitlement to both time and money, including reasonable profit. Thus, if a site is closed or access is restricted because of COVID-19, this may be a route to recovery. Remember to put those notifications in. I've put on this slide also clause 6.7. Remember, as contractors, you do have responsibilities in relation to health and safety. I think we've lost the current slide, so we should be on slide 7 from the Clyde & Code. Thank you very much. Think also about whether you can raise a request for a variation and therefore shift the emphasis on the engineer to make a decision. You will also have noted in the press various encouragements given by the government to think about pricing, to think about achieving efficiencies. I'll therefore encourage you to look at and understand your clause 13.2, which relates to value engineering on a project. And because I've mentioned it on almost every slide, clause 20, notifications, please make sure they're in on time. So in summary, and taking a step back, I've had to think about what my chief concerns are. And my concern is we have a situation at present whereby a lot of parties are triggering the COVID-19 issue with what is sometimes quite generic claims notices. And this is why. It's because you don't want to miss notice deadlines within contracts. However, in response, employers are uniformly rejecting these claims. The notices often come with little or no demonstration that COVID-19 has been the actual cause of a delay, for example. Employers will be naturally suspicious and consider contractors are potentially using COVID-19 to claim for delays or events or issues that were present before or occurred separately to the issues aligned with this epidemic. I therefore encourage you to think very carefully and be as defined as possible in your communications and notifications with the employer under the contracts. And I think I will stop myself speaking and hand back over to Michael, who's going to talk a little bit more about the specific laws and dispute resolution.
Okay, next slide, please. So I am going to pick up on where Matt left off and talk a little bit about the applicable law, particularly, I suppose, in a situation where a contractor or on any project there is an amended form of FIDIC and ask whether the applicable law will come to the rescue and introduce some rights that perhaps might not otherwise be there. In other words, on pretty much every project in the UAE, because I think there are a few projects where FIDIC contracts are unamended. And even where they are unamended, the question, I guess, arises whether the applicable law will introduce some additional rights or amend those rights that are set out in the contract. And then finally, I'm going to look at dispute resolution quite briefly, but mainly for the purpose of working out or trying to work out how a lot of these provisions are going to actually be applied in practice. So starting with the UAE Civil Code, it's clear in the UAE Civil Code that there are provisions that deal explicitly with force majeure and impossibility. I think the two terms are probably used largely interchangeably by the drafters of the UAE Civil Code. And you'll find those, the most relevant ones, certainly not all of the relevant provisions, but the most relevant ones are Articles 273, 472 and 893. I'm going to come back to those and look at them specifically because they are very important. Before I do that, UAE onshore law, which is what the UAE Civil Code is not, of course, the only source of law that we are dealing with in the UAE. There are financial free zones, particularly DIFC is probably the one that has the most traction, but ADGM as well. And DIFC and ADGM both have their own legal framework in which the UAE Civil Code does not apply. So it is not relevant and doesn't apply if the contract has applied the DIFC law or for some other reason of jurisdiction, DIFC or ADGM laws apply to your contract. As many people will know, DIFC introduced laws that essentially govern most of the commercial activity within the geographical boundaries and if you choose that law as well. But the default position under DIFC law is that if something is not dealt with in the law, then it reverts to English law as the backup default position. In relation to contract law, though, that is codified and it is found in DIFC law number 6 of 2004, the reference for which is there on the slide. And unlike under English law, which actually has no concept of force majeure, at least not specifically, and I'll come back to the substitute for force majeure under English law in a moment. DIFC contract law does specifically provide that in the event that the performance of a contract is impossible, that the party who is in the position of being unable to perform is excused from performance, and that is found at Article 82 of DIFC contract law. Unfortunately, I haven't put it up there, but I will just quickly read it out because there are a couple of conditions that it's worth drawing attention to. It says non-performance by a party is excused if that party proves that non-performance was due to an impediment beyond its control and that it could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract, or to have avoided or overcome it or its consequences. So it must be an impediment that is beyond the party's control. It must have been unforeseeable at the time the contract was entered into and unavoidable in terms of its impact. And that is a common theme, actually, in relation to most force majeure provisions, including under the FIDIC contract and, as we'll see in a minute, under the Uae Civil Code. There is a fairly consistent pattern when it comes to defining what amounts to force majeure. I should add that in common with the FIDIC force majeure provisions, payment obligations are excluded from the force majeure mechanism, and so therefore a party cannot rely on force majeure under Article 82 to delay or avoid payment obligations. ADGM has a different legal system, but in very broad strokes is similar to the position adopted under DIFC law, save that contract law in ADGM is not currently codified, and therefore the position defaults to English law. And as I said earlier, there is no force majeure in general under English law. The concept that is most closely associated with force majeure is called frustration of contract, and it's a slightly archaic and very narrow principle on which contracts can be avoided or annulled, cancelled and terminated. But it's not a very, it's certainly a narrowly defined category of circumstances in which that sort of form of relief can be called upon. So under ADGM law, the position is certainly less attractive and advantageous to a party seeking to use force majeure to release itself from certain obligations. Okay, so reverting, as I said I would, to the Uae Civil Code, to those provisions, Article 273, 472 and 893, I think they do bear looking at a little bit closer. So can we have the next slide, please? I have set out the entire clause, and I'm afraid I am going to read it because I think it is fairly critical in terms of the discussion we're having, but I won't read the next two. In contracts binding on both parties, if force majeure supervenes, which makes the performance of the contract impossible, the corresponding obligation shall cease and the contract shall be automatically cancelled. And then I think, in fact, the second paragraph for our situation is much more relevant. In the case of partial impossibility, that part of the contract which is impossible shall be extinguished, and the same shall apply to temporary impossibility in continuing contracts, etc. And construction contracts are continuing contracts for that purpose. They are not sales contracts. For example, you buy a piece of plant and equipment and you pay the price and ownership transfers. So we are in a continuing contract situation in construction. And I think Article 273 does provide a clue as to what the answer is to the situation where it is only partially impossible to perform a contract, certain obligations like completing on time, but it's not impossible to complete full stop, or it is not possible to make as much progress on a particular activity as one would have hoped or as programmed. Can we have the next slide, please? Then we have similar provisions at Article 472 and 893. I've included Article 893 because that falls within the section of the Civil Code that deals specifically with contracts for the provision of labour and materials. And so it is the section that covers construction specifically, and it is an article that is perhaps less well drafted than the previous article, but it nevertheless does give rise to the right to terminate or cancel a contract if completion is prevented. So can we have the next slide, please? All of those provisions are really obviously open to interpretation and application depending on, and the outcome is likely to depend to a large extent on the forum in which you find yourself if you ask the question about what the impact of those articles is. And that is why I've included this final slide to under which to discuss really what the practical application of these provisions is likely to be, depending on which forum you find yourself in if a dispute arises. The advantage of the courts, both onshore and in financial free zones, is that we do have the benefit of some history and judgments of what the courts have done in the past in similar sorts of circumstances. Those of you who have been here long enough will remember the years of 2004 to 2008, when there was rampant material price inflation and shortages of goods, and cases came before the courts in which parties were arguing that this was unforeseeable, the shortage of goods and the demand for steel and other raw materials, and that relief should be granted from the fixed price terms of the contract. And then, of course, the roles were reversed only a few years later during the downturn, and developers went back to the courts and asked for relief from their obligations because the property market had crashed. In both cases, the UAE courts generally, were unsympathetic, I think it would be fair to say, and determined that both recession and inflation are ordinary economic events that can be anticipated. What we don't have, unfortunately, as far as I'm aware, is a sort of directly parallel situation where the courts have been asked to rule on an epidemic or pandemic. But one can draw from the judgments that we do have some of the principles. Well, I think in fact 4 key components of the test that the courts are going to apply to determine whether force majeure or impossibility applies. One is that, well, the first one is that the event on which a party is relying must be exceptional. It must be universal in its impact, and it must be unavoidable in its consequences. And we saw some of those elements being picked up in Article 82 of the DIFC contract law. So exceptional, universal, and unavoidable. I think all of those we would probably tentatively, bearing in mind what Matt said, agree that we could say that the current situation fits within. But the fourth one is impossibility. And this is more difficult because impossibility can be applied either to the entirety of the contract or to individual components. And somewhere in between, it ceases to be impossible to perform a contract based on the current situation. And so depending on how you apply the impossibility test will really determine, I think, in reality, what the courts are likely to do. And then just turning finally to wrap up arbitration. I mean, arbitrators do tend to be slightly more sympathetic to the commercial realities of life. And so depending on the tribunal one has and the individual members of it, I think broadly one can expect to get a fairly sympathetic hearing from a tribunal, provided that the claim demonstrates the link between the current pandemic and the relief that is being sought, whether that is time or cost, which is something that is certainly more difficult. So that hopefully provides a useful sort of practical view as well at the end there.
Fantastic. Well, thank you, Michael, and thank you, Matt, for that really comprehensive presentation. We've had a lot of requests for people to have access to the slides. So yes, we will send you the slides or provide you with access to the slides. And I know that some of you want to contact Michael and Matt directly. Both of their contact details are contained on the slides. Now, we only have 10 minutes to go on this webinar, and I have a lot of questions for Michael and Matthew. I'm going to try and get through 2 or 3 of the questions, but then we're going to run out of time. So we will respond by email where possible, but also, as we said at the beginning, we're going to do, this is a regular series of webinars, and so it seems clear there's so much interest in this topic. I think we might have to revisit it in one of our future broadcasts, so we will do that also. Just in no particular order, Matthew, we have a question here. In reference to all other clauses in the contract except force majeure, one, could you please elaborate on proving causation and a direct logical link to the impact and effect? And part 2 of the question, what measures by a contractor can be viewed as valid mitigative measures and would a non-performance on mitigative measures be used to counter any claim? So the person has asked Matt this question, so if you want to come in, and then perhaps Michael might want to say something also.
Yeah, okay, thank you, Richard, and thank you for the question. Thank you for all the questions. I've tried to reply to some of them by text, and I was listening to Michael as well, by the way, but multitasking. So in relation to causation, I see this as an area where there is going to be a lot of difficulty. We've been hit with an event out of the blue, which has come onto our projects, projects which already have ongoing issues. So, for example, if a contractor and employer are already talking about delays caused by inadequate design provided by an employer, and then the COVID-19 issue comes in and has caused additional delay and disruption, what contractors and their advisors and consultants will have to do is forensically separate out these various causations. And so the best course of action that I've been discussing with contractors recently is continue the same course of investigation, notification and claims that you have been doing with the everyday site issues. But then also your teams need to keep a log and keep as much evidence as possible in relation to how COVID-19 is impacting your works. And to the extent that raises any cost or time impact, that needs to be notified. Now, one thing that generally isn't thought well of in claims are global claims for disruption. In my view, we are entering and we are in a period where we have classic disruption. We have an event which has come in and which is making contractors' ability to undertake the works less efficient. And so to help us lawyers, to help your consultants, to help yourselves in any claims, keeping really detailed records of how things have changed now as to how things were before will put you in within a better position to bring claims in the future. So it's really about, and you've heard this to death, records, records, records. Keep a really good record so your consultants can come in and untangle the mess that this has created. I think the second point was on mitigation as a defence. We often see employers, engineers alleging that mitigation wasn't carried out. I go back to my clause 13.2, think about whether there's any value engineering that can be undertaken, but you should also, just as a practical course of action, be thinking about mitigation. And so when you are putting your claims in, when you are putting your notifications in, don't just notify the negative, also flag the positive of what steps you're taking to mitigate those issues. But remember, in relation to some mitigation measures, you may need an instruction from the engineer or employer. So make sure you're not breaching your contract by carrying out mitigation. Final point, and then I'll stop. Mitigation is often involves the use of more labour. And what we find is that contractors, because they want to get the job done, put more labour on to accelerate the works to catch up with delay. The problem that we sometimes find when we're in a dispute situation is proving that that instruction came through to increase your labour. So run it by the engineer and try and obtain instructions wherever you can.
Okay. Michael, I've got a question here. It says, I'm assuming that the Civil Code will take precedence over provisions contained in the FIDIC contract. Is that correct?
Right. That is a good question, of course, as they all are. That's a particularly good question because I didn't answer it for a reason, which is because it's quite difficult to answer. Essentially, the UAE Civil Code does contain mandatory provisions which overrule anything that the parties have agreed. And there are about a dozen of those that state specifically that they are mandatory and that they overrule anything that the parties have agreed. And they are things like decennial liability that people are probably familiar with. You can't contract out of that. And the right to adjust liquidated damages under Article 390. But the force majeure provisions do not state that they are mandatory and overrule anything that a party has agreed. That doesn't necessarily mean that they won't, because there is a principle underlying the mandatory nature of civil code provisions, which is that they are in the public interest, or they're matters of public order. So it is still possible for provisions of the civil code that are not stated explicitly to be mandatory, for them to be mandatory if they are considered to be matters of public order. But I am not really aware of any circumstances in which the courts here have actually said that provisions are mandatory when they haven't been expressed to be. So if you had to ask me to come down on one side or the other, I'd probably say that the force majeure provisions of the Civil Code are not mandatory. So if you have provided in the contract for force majeure, then the Civil Code will not apply. But if the contract is silent or there are gaps on force majeure and impossibility, then they will be filled by the Civil Code. And I think if parties have just deleted, for example, clause 19 in its entirety and left a gap where it used to be, I think that will probably be filled by the Civil Code. And so then in those circumstances, the answer would be yes. It does override the contract because perhaps the intention was to have no right arising from force majeure, but the effect won't be the same. It will be actually that the provisions of the Civil Code step in and deal with that issue and fill that gap. I hope that helps.
Thank you. One final question before we run out of time, and I don't know which of you is best for this. What is the status for projects that have not started or contracts that have not started, but a letter of award has been issued recently in February but the project has not started. Is there a remedy for contractor time and cost? Any thoughts on that? So this is, I guess, stuff that maybe the events were foreseeable.
Should I deal with that then? Since Matt's very quiet.
No one jumped in there.
Looks can stand up, Michael, and you blinked first.
That's also a very good question. I think that's very fact specific actually, because as we've discussed, this situation, the virus is not preventing projects from starting on site, and therefore it wouldn't be possible. I don't think it would be feasible for an employer to say that that force majeure has intervened and that the work should not start and that the contract should be cancelled. I think here we're talking really about specific obligations under the contract, like the obligation to make proper progress and so on and so forth, not the entirety of the contract. So I think it would be personally, and without knowledge of that or carrying out any conflict checks and giving specific advice, I think it would be difficult for somebody to say, right, the whole contract must be cancelled or go on hold because of the current situation. But that's not to cut across what other rights might exist, like there might be a right to terminate for convenience or to suspend the work and to cover the costs of doing so. That depends on what the contract says.
Okay, thank you, Michael. I'm going to bring the session to a close because we've reached the end of our time limit. Now, we've got a huge number of questions that have come in and chat comments as well, and thank you all for submitting those. We will answer them. We might have to do it by email or we might have to do it in a future broadcast. Clearly, there is a lot of interest in this area, and there have been a few questions coming in on the financial implications of the crisis as well. So I think that's a topic we have to return to in another edition as well. The slides will be shared, and the recording of this broadcast will also be put online. You will be able to see it on the Mashreq Hub that I mentioned earlier, and on MEED's YouTube channel, and we'll circulate links to the recording as well. So you can get all of this content and engage with us. But thank you, firstly and foremost, thank you very much to Michael and Matt from Clyde & Co. You've given us so much time and information today. I know that this is really important to people in the market. So thank you both for your presentation today, and well done.
Thank you.
If we can go back, you're welcome. And if we can go back quickly, Nabil, to the slide deck, just a couple of, if you go to the next slide. Just a reminder for the construction think tank white paper, which is dealing with standardized contracts for construction in the UAE. In the chat box at the bottom of the screen, you can download this report, which is also, you can see it on MEED.com, and there's a link on the blue text on the screen. For everyone interested in this content, this report, I think, this white paper is pertinent and hopefully important. And then if we go to the final slide, Nabil. So just on behalf of, I'm going to hand over to Mohammed to say a few words at the end, but on behalf of MEED, thank you all for your interest. Please send in suggestions for themes and topics that you want us to cover in the series going forward. Thank you for your engagement. Thank you for the panelists today. Stay safe, be sensible, and I look forward to seeing you next time. Now I'll hand over to Mohammed just for a few words from Mashreq.
Thank you very much, Richard. Apparently it was a very engaging event that we have had here. It is encouraging for us to continue to do this event going forward, and we will definitely tap onto different topics that the industry requires. Just to reaffirm that Mashreq will continue to be supportive of all clients in this industry, and I encourage everyone, all the companies, to reach out to their bankers and to see what are the possible help that could be achieved during this unprecedented disruption that we are facing. Thank you very much. Stay healthy, stay safe, and stay connected.